used to have my bosses ticked off because they like you to be at a podium when the judges are talking to you. Legal aspects of computer network security. Basically, here's what we're going to cover. We're going to look at some of the top precedents we had going on. The legal aspects of what you can do for computer network security. And then apparently something happened recently with Google and NSA that everybody's curious about, and the legal aspects of that, so I get picked up to talk about that. And if we have time, we'll move into some aspects of cyber warfare. When I'm invited, I always look at who am I speaking to. You know, at conferences, if you're not repeating, you don't know who you're talking to. So this is what I was given for my target audience for what we're looking at. And from that, it's that high energy, fun environment, which I like, because I like to semi-entertain as I do this. Ask questions at any time. That's the main thing. It's interaction. If you have questions on some legal aspects that you're doing for computer network security, please ask away at any time. We were just talking up here ahead of time about going to conferences. I am in the third track here, which kind of deals with law aspects of things. And whenever I go to a conference, I always like to try to get one or two nuggets of something that I didn't know, and if I can go back and say, okay, that was worthwhile. So hopefully you can take away one or two nuggets from things as you're doing as we go forward. I got to give the disclaimer that everybody gives. I am here. I work for the government. I'm not here to help because I'm here on my own time right now. So if I was here on the government time, I'd be here to help. But so anything I say is my own. Any influence that has been exerted upon me by any institutions that I've been affiliated with, I'm sure was done unintentionally, and so they wouldn't want to be blamed for my opinions whatsoever. My background, Robert Clark. I was the legal advisor for many years to the Army CERT. I moved on from there and was the legal advisor to the Navy CIO. And then I jumped ship and went and was the last legal advisor to the U.S. CERT. So that's my background for this. In between there's a stint I don't like to talk about a lot. I was a lawyer for the SEC for a while. And I don't really like to talk about it because it was during that time when like the economy went south, but my pornography business went really through the roof. You know, you can do a Google search for that aspect. Timely jokes. For those of you who speak code, there's my background for you. And one aspect about lawyers. A town with one attorney, you can make a good living. You can make a decent living. A town with two attorneys, you can make a great living. Okay? So, and it kind of comes into a joke that I once heard, and it was when somebody said, what's 1 + 1? Now, you computer scientists, you mathematicians, if you ask you folks, you'll say 1 being a positive number, you know, 1 being a positive number, that would be 2. If you ask an attorney what 1 + 1 is, they'll say, what do you want it to be? And that really is true, because if you take your fact pattern and you give it to any numerous lawyers, you will get a different answer depending on what you want the answer to be. And so that's very important to understand that when you're talking with lawyers. So you can get a fact pattern. We can talk about things here. I'm going to try to stick to what's called black letter law. I'm going to try to look at what the facts were that presented to the case, what the judge said, what the law was from that. But if you take these facts and ask someone who's a defense attorney, who's from EFF, that's representing you, they're going to give you a different answer from the aspect of it than what a government lawyer might give you. Now, the only thing to remember from that aspect is, and I used to tell my clients this all the time, at the end of the day, I'm going to go home and have my steak dinner. So what you're really risking or what you're willing to put on risk is, you know, is possibly jail time. So what you're comfortable with, people have different bents on that. Who knows what that last acronym is by any chance? You guys are so sharp, I tell you. You guys must go to Black Hat and DEF CON too. I am not your lawyer. All right, one more thing. I'm not Richard Clark, so I can't sign this book. I'm no relation to him. He's not my dad. He's not my uncle. And God forbid, he's not my brother. He's 60. I hope I'm not getting there yet from that aspect. But if you do pick up his book, make sure you take it to the book signing and not like your iPad or your electronic version of it, because like when he writes his name all over the cover, it ruins your iPad, and so you can't see anything. All right, I like starting off with this case, although it's interesting because it's a 2005 case, so that's kind of getting old, particularly for internet standards. In this case, Mr. Prochner was busted coming across the Canadian border because he had a bunch of credit card numbers written on a piece of paper, and so they got him for credit card theft, identity fraud, and they elevated his sentences. They did a sentence elevation because he used special skills to get this information. So he was supposed to be sentenced to about 0 to 6 months. He ended up getting 25 months. He had some other elevating factors with it, but when you get your sentence elevated, it bumps it up for how much time you can do in jail. It was an interesting case because the judge looked at, did this require a special skill to pull this off? And the court basically said, and the reason I share this is because the court has recognized your profession as requiring the special skills. For jail time, that's not a good thing, but you guys are special and you have special skills. Now, in this case, the interesting aspect about this, Prochnow had the right to remain silent, but he apparently did not have the ability to remain silent because he gave a detailed confession on what he did in these steps, and that was the evidence the judge used to say you have special skills. Now, he was arguing, hey, wait, I had no formal training. I didn't go to school, I didn't get an education. Judge recognizes that sometimes you can self-teach these special skills, and this was an interesting case. I do note that the judge included pilots, lawyers, and demolition experts as having special skills. So an interesting aspect from that. For my perspective of, I now do oversight and compliance for DHS for cybersecurity information. And from my perspective, how an IP address is treated is pretty important to me. If you're doing cybersecurity and an IP address is considered personally identifiable information, depending on what company you're with or what you're doing, you're going to have to protect that under different standards. So to me, this is a pretty key thing in which this case ruled that an IP address is not personally identifiable information. The EU does not treat it the same way. So it's just kind of a note to take away on this. Now, there's been a lot of cases out there talking about IP addresses, that it's a four-part number, that it's like your telephone number, that there's no reasonable expectation in a telephone number, so there's no reasonable expectation in your IP address. So that's what came out of this case. This case was a Microsoft case that basically said that Microsoft would not obtain personally identifiable information for your computer, and they got a class action suit saying, well, when I'm sending, you're updating my software, you're getting my IP address, that's personally identifiable information. The Microsoft case attorneys cited precedents, which is always good, from a 2006 and a 2007 case, one out of the Sixth Circuit, which is kind of your Midwestern range up in near Minnesota, Michigan, and Ohio, and then the Central District of California. We always like it when the Central District of California gets cited, because the Ninth Circuit out there, which obviously is handling those whole areas of California and everything, is always a very, very robust practice for cybersecurity law. And basically, the court went on to say that you're right, an IP address is not PII. They had in their glossary at the end of the EULA that, what could be PII, and it included the IP address. But they argued, we never incorporated this by reference into the actual agreement, and so therefore it shouldn't be included in that, and the court bought off on it, and so an IP address is not personally identifiable information. Secure your wireless router. These cases are the ones that EFF does really like, and I agree with them too, in terms of access. If you hop on somebody's wireless router, is it a crime? And this one was an interesting one from a flip side of it. Basically, it was looking at what the question of, in the internet age, of communications and the internet. The Quan case that's up here just went to the Supreme Court. It was argued this week. And so we're going to talk about that in a little bit about Quan. It has to do with workplace monitoring on this. But this was basically looking at an unsecured router, a shared iTunes library, and a home wireless aspect. And for Fourth Amendment, the key aspect on this is, can you have a Fourth Amendment search in your house? Or in your house, can technology look inside your house and not be a Fourth Amendment search? The Kelo case on that one basically was a guy had a grow site in his house, and the cops knew it, but they could not bust him. They couldn't find the evidence to get the search warrant. So they went and got thermal imaging because they had the lights growing the marijuana going up in there. And so from the thermal imaging, they went and they looked at the house, saw the big signature that gave off. Based on that, went and got a search warrant. And the court said, no, you can't do that, because you can't use technology that's not in general public use to enhance your sensibilities to look inside that house to find out if there's a crime being committed in there. Now, I can take a drug-sniffing dog and have him sit on your front porch if it's, where guests are coming in and out. They're saying that's in your curtilage, which is where your property is, but it's such a common access way. I can have a drug-sniffing dog sit there, and if he alerts, then I can use that to get a search warrant. But as far as the thermal imaging, I can't do that. I guess, one, they haven't ruled if a dog is technology, and two, I guess dogs are in common use. And so it's not, it's in public use. So this is what the court was looking at on this one. The facts in this one is what you typically would think. The neighbor hops on her wireless network, gets bumped off for some reason, and she picks up the guy's, Belkin 54G wireless network. She connects on that and using her iTunes, and as she goes through her library, she sees the dad's LimeWire tune. She goes, wait, that ain't mine. And she observes a few files, and this is the disgusting part of the job, and so I'll spare you the names and the titles of these things. And she calls the cops. Cops come over and say, can you do this for us? So they do it. She does it for them again. They go get the search warrants, and, the next is all history. They're arresting the guy. Now, when courts are discussing facts, they usually will start tipping their hand on which direction they're going to go, on whether they're going to find it a search or whether they're not going to find it a search. The judge I used to work for, when we used to have motions to dismiss cases, I used to tell attorneys, the judge is going to go through the facts, and he's going to start talking to one attorney. If he's not talking to you, shut up, sit down, because you've won your case, because he's going to talk to the guy who's losing on this. And this is what courts really do. They start looking at basically what is the aspect of unsecured wireless routers, Joy routers, ubiquitous out there. So you can kind of tell, okay, well, he's going to be looking at this. And he starts doing an analysis of wireless phones and hardwired phones. Basically, you don't have the expectation of privacy in a wireless phone or wireless phone that you do with a wired phone. And that's exactly the path he goes down, saying, look, you got this unsecured wireless router. It's broadcasting out there. You don't have an expectation of privacy in what you're broadcasting out to the world from that aspect. And then they went on to say, okay, now what about just because that's aspect, what about the library that was in there, the ShareTunes account? The guy says, I could have an expectation of privacy in that. And the judge said, no, you don't, because on your iTunes account, it's defaulted to closed. You had to go and actually open it up to share it. And so basically this guy got busted for having child porn on his iTunes account. One of the big things that cops are doing now is they're hopping on LimeWire to find out where child porn is at. And this is an interesting case in where Mr. Barowie, he actually, was using LimeWire, and he tried to set it up to a point where his files were not out in the public domain. So he's actually evidencing a subjective expectation of privacy in his account. Problem was, he wasn't technical savvy. He screwed up. He never got it turned on properly, and the court said, too bad, so sad. Just because you're not technically savvy, we're still going to allow the search to be a good search on that, and so he got busted for child porn. Government workplace monitoring. This is where the Quan case is coming in. So if you are in this business where you've got, for your employer, you're looking at what's on the network. The case up there is United States v. Atkins lays out a great summary of all the cases that talk about workplace monitoring, how to go about doing it, banners, notice to employees, training, the whole aspect on it. Quan had the whole same things. Quan was a cop, and he was giving a text pager to do things, and he said, use it for government purposes. If you go above it, anything you pay for, hey, that's on you. But they had the same policy saying anything and everything you do on this may be monitored and may be used and looked at. But unfortunately, the cop who was supposed to collect the money of everybody using this told him, said, look, I'm not going to look at this stuff. I don't care to look at this stuff. As long as you're paying for it, it's your own thing. That informal policy nullified the formal policy, and so basically that's why it went to the Supreme Court and said, you've got an inconsistent policy in this. Atkins talks about having that consistent policy going through. I'm going to come back to Quan hopefully in a little bit, because I'm going to go into Stengart here. This was an interesting case where they had a policy, and basically she had her web-based email that she would log into with her password, and she sent some messages to her attorney. They held that the policy was not clear. Now, we always say bad facts make bad law. These aren't really bad facts, but the facts of this case is you're dealing with the attorney-client privilege. And as the court said, the attorney-client privilege is the greatest privilege in the world. It's the second privilege after Adam and Eve and the marital privilege, because they went way back. Because why? They're a judge, they're an attorney, and so they want to protect their own space. In this case, she used her web-based email, her Yahoo account or Gmail account, to send her attorney some messages. And they had a policy that said anything and everything you do on your employer-provided laptop may be monitored. Now, the court said, well, the policy was ambiguous, because then it said, this is for business purposes only. although minor personal use may be used. I've seen these policies all over the time. I'm missing where that's ambiguous. All and everything may be monitored. That's not ambiguous. And this court said it did not say your personal web-based email that's password protected that you use to send attorney-client privileges to will be monitored. That's what they said. It's a little extensive. I've heard this argument before. Yes?
So that was a legal action that she was doing. She was communicating with her attorney. Turn around. What if she was selling drugs with my partner?
See, that's an interesting point. And this is the question is, okay, so she's doing that attorney-client privilege. What if she's turned around selling drugs or something like some criminal nefarious activity? Would the court have ruled the same way? An interesting aspect.
Well, they didn't go into her actual email. What they got was the remnants of, cash information that was on the local computer.
They basically took the laptop, did a forensics on it, and found it. Now, here's the other aspect on this one. So again, bad facts tying into here. Professional code of conduct for attorneys. If I find privileged material, I'm supposed to not read it, and I'm supposed to notify the other side that I found privileged material and turn it over. So I've got another aspect here in terms of the fact that I have a professional code of conduct that says I've got privileged material I'm supposed to look at. There is case law out there using an employer-based email system to communicate with their attorney was not privileged communication and is not private. And that's what the attorneys were saying in this one. This wasn't privileged information. And by the way, when you turn something over to the third party, it's not privileged information. So there's arguments out there, again, and this goes with IP addresses. When I turn the information over to an ISP to transmit it for me, it's no longer privileged information because I have to share it with a third party. If it was criminal activity, would the court have come down in the same way? One aspect on this. This is a private cause of action, a civil action where two people are suing each other as opposed to a government action looking at this from a Fourth Amendment perspective. And that's what this case looked at. If I'm not going too far. They looked at the tort in intrusion on seclusion, which does look at some elements that you look for a Fourth Amendment. Objectively, is society going to look at this and the subjective intent of it? But it was an interesting aspect in this in that they said, and they did say, we're going to go cite with her. The emails should not have been read. They should have been turned over, and so they're remanding it back to see if this firm has to be withdrawn from the case. But there are some conflicting cases out there which basically do say, no, I can monitor your web-based email system. So it's one of these aspects where the judge said, we expect you to write policies to be able to monitor your network. We're not saying you can't. We're just saying you can't be looking at the content of email going to an attorney. But yet, when I talk to computer security professionals, that's the thing. Okay, this isn't, and we'll talk about this in a second here, this isn't like the old phone companies where if I monitor the first 20 seconds, I can find out where the fraud's coming from. In computer security, I never know where that fraud's going to be coming in, so I don't know if I'm going to have to look at content to see where that fraud comes through. And that's the fun challenges on this.
In a policy, if you say that you may monitor what practice if you haven't
practice.
In the last 5 years, would say, and you monitor one person, is that a reason to not put that in your policy?
Can I ask you to table that for a second and remind me about that, because I have a terrible memory and I'll forget. The Quan case, which I'm going to go, this was said earlier in one of the other presentations I had here. There's no one statute that discusses privacy from that aspect. It's made up of a bunch of things. As a matter of fact, privacy isn't even in the Constitution. It was created by the court on this. So it's an interesting aspect when we're dealing with privacy and when we're doing workplace monitoring. To do network security, going through really fast so I don't waste time, it came from an aspect of a common law principle about dealing with property, and that it's kind of a self-defense type principle. If you're in the right place at the right time, you can defend what you've got. It really is the trespass to chattel, and chattel is simply the aspect of it's my property. If I give you my lawnmower, or if you come over and borrow my lawnmower, and the interesting point on this one is that part where it says we like the aspect of prevention as opposed to post-action recovery. And what that means is you borrow my lawnmower, they like it if I'm actually got my lawnmower locked up in my garage so you can't get to it. If you just come over and get my lawnmower and take it over, and then I've got to breach the peace to get it back. I kick down your fence. It's the middle of the night. Dogs are barking. Cops show up. We don't like that aspect. We like the prevention aspect of protecting our chattel, which really kind of comes into computer network security. This has been codified under the Electronic Communication Privacy Act. It basically says if you own a network, you can defend it. And that's not eavesdropping or illegally obtaining electronic communications. And it comes under what we, as attorneys like to try to be cute. And we say, 2511 sub 2 little a little I. We don't have a lot of fun in the world, so we try to laugh wherever we can. And so what we're talking about for computer network security is an aspect of multiple disciplines make up computer security. And so you'll have cops, you'll have intelligence, you have network operations certs. And depending on what happens, people can have, jurisdiction over the thing. So, if I've got an incident in which one of my sensors pops for porn, I've got, a violation of company policies, so certain NetOps and NOSs are going to be involved. But I've also got a crime. So I've got an aspect of, I got a possible crime, I should say. Because when I pick up the phone and I call the cops and I say, one of my sensors just popped for porn, what's the first thing they say? Is it child porn? I don't know. I didn't look at it. So I hang up the phone. I call the sysads up. Hey, guys, was it child porn? They say, I don't know. We didn't look at it, which is a lie. Because when porn pops, they go and look at it immediately because, what the hell? So they go and look at it and make it look good. And then they call me back and say, no, it wasn't child porn. And the cops are gone. So it's no longer a law enforcement action. It's now just a company action. So a lot of people have jurisdiction over what they want to do for this. So what are we talking about? We're talking about, from some aspect, getting the attribution on some level. When my first guys told me, computer network security has nothing to do with attribution, I fell out of my chair and whacked my head on the wall really well. And when I woke up, shaking my head, I said, what the hell are you talking about? It's not about attribution. And they go, I don't need to know the person who's attacking me. I don't care for computer network security who's attacking me. I need to know what the vulnerability is so I can defend against that and stop that from coming at me. Who's attacking me? That's a law enforcement or an intelligence function. From a computer network security profession, I don't care. I'm going to pass that off to somebody else to do. I'm concerned about just protecting against that vulnerability. Give me your question again.
If there's policy states that you may monitor or you do or popping,
right.
subject to.
Don't be inconsistent with that. Okay. I don't want to forget. Again, there's the statute. It has to be a necessary incident. And this is what I was talking about a little bit before. Come on, pal. This is why problem with letting my son use my thing here. All right. It's a service provider exception. It's not a criminal license. When you do your computer network security, there has to be a reasonable nexus to what you're doing in terms of your monitoring. It's not unlimited for whatever you want to do. Getting ready just to use the damn buttons. All right. And this is what I said before. In that Commonwealth versus Helms, back in the blue box cases when they tried to get the hackers of phones, companies were monitoring like the first 6 to 20 seconds of the phone conversation, got their information and punched off. In this case, they recorded the entire conversation and the court threw it out because there wasn't a reasonable nexus for what they needed the information for. So now they were illegally obtaining information in violation of the Electronic Communication Privacy Act. So it has to have a reasonable nexus. If I find out what the fraud is, who the person is, I can punch off the line. I don't need to listen to the entire conversation now. For computer security, how do you do that? Where's that vulnerability coming in? Is it coming in at the beginning of the three-way handshake, the middle of the three-way handshake, or the end of the three-way handshake? And that's what causes the challenge for what reasonable network management is. I've thrown the Comcast case up there when they were taking care of some of the peer-to-peer stuff on that. Again, because it's a great case to read when you're talking about what is reasonable network management. You have on your network that you own, you can. What's the boundary of that ownership? Yeah, that's a good question. I was wondering if we were getting there. Come on, man. All right. The boundary on that one, how we monitor. So I'm going to take time to get back to your question on this one. To do this monitoring from a workplace aspect, and we're going to go here, then here, I've got to have, basically the best way to do it is you get the consent of your users so that you can monitor, which means you have banners. There is the shrink wrap, clicking, browsing, the aspect of actively clicking on something to get to the next screen or just getting to the next screen. You wouldn't believe how many dollars in lawyers you guys wasted in tax money from federal government attorneys arguing about this. Oh, no, they got to click an agreement. Oh, no, you can just go right by it. No, they got to click on the agreement because it's a positive step that they saw the banner right there. Nobody reads it. We all know that, but at least they had to click on it. I agree to get through it. So now they've got notice that you've got a banner on there that the system's going to be monitoring. Now you got to pick the right wording for what you're doing. All things will be monitored. You have no expectation of privacy. We will read this. It's an interesting aspect, but as you're dealing with this, and if you're dealing from the technical side with your policy folks, you got to lock this down in terms of having an airtight policy for it. User training goes back to if you haven't ever monitored, if you haven't ever looked at it, you've never looked at anything, and all of a sudden you do it, yeah, you're probably going to have a problem. I mean, court's going to say, yes, you have the policy, nobody knew about it, and there are cases out there that said, yes, you have the policy, you never sent it back out again, you never had any refresher training on it, so you can't just say, okay, I'm going to throw it down and use it now because you've never enforced it. From now, a couple aspects of it. The government clearly cannot enforce it against one person because you're targeting an individual from that aspect of it. So the government has problems with that. From an employer aspect of life, yeah, I can't. But this is where you start getting into the battle of the experts, where you're going to bring in your sysads and say, okay, monitoring, what's that involve? Well, we've got sensors on here. We're looking for things to pop up from that aspect, and what happened here. And typically these cases are always pouring cases because that's what the sensor's popping off on, and so that's what you're getting it. And then, the discharge of the employee goes from not so much the misuse of the policy as to it's an age discrimination, or it's, some kind of a workplace complaint, so now you've got an employment aspect of it. But you're absolutely correct. If you have a policy, a key to it is enforcing it, making sure there's knowledge about it, awareness, repetitive training on it. The user agreements are consistent. For our aspects, we have web policy, which is that outward-facing web policy to tell users coming in, hey, this site's monitored using software for computer security purposes, who we're going to share the information with. We got to get rid of that expectation of privacy so we can monitor it. How do I monitor it? How far can I monitor it? I should save this for the cyber war aspect of life. But this is the aspect of what you own and where you go up to is what you can monitor. Once you go out, you're now, and words are getting thrown out and mixed up all over the place. You're now into an active defense, and there's some aspects in terms of what's an active defense. Scott Moulton, who owned, I can't remember what his company was doing some security testing for a company, and he was pinging on a system. And they said it caused a denial attack on it, and he went to court. I can't remember if it was civil, or I think it was a civil action on it because there's some problems with it. And the court said there's no testimony that actual pinging, because no one spoke to it, was actually slowing down or causing a defect or a diminished latency in the system, slowing down. There's been a couple cases that have bounced back and forth on the Intel case of the guy flooding with emails on whether the system actually suffered any kind of detriment, slowing down, going back and forth. But on the safe side of it is defense is monitoring what you own inside your network. Going outside of that is starting to become an active defense, and if you're going to do that, get involved with your attorneys early and often. Yes?
Well, how do you think that's going to relate to the Carson Jersey case with who monitoring
Webcams?
the webcams in people's homes? Where's the boundary?
Where's that boundary? Oh, that was clearly illegal. I mean, I rarely, I usually, here's the law, blah, here's what the case said, here's what plaintiff said, I usually try to stay in that realm of the world on life and that, but that's an aspect where I'd be settling that case so damn fast, yes.
Where is the boundary for personal equipment that's in your home, that's your property, but utility, your cable provider or electric company is in your premises area, has the service to come out, or unless you go off the grid and do your own.
Depending on where you're going with that question from that aspect, and I hate them, I stay away from them, but it's going to be your EULAs I mean, to say where that boundary is, if I'm an attorney that gets into a case of that where there's going to be a debate on that, I'm going to be looking at the terms of the EULA to say where that actually lies within that. And even doing that, again, playing devil's advocate on both sides, if I'm, the provider, I'm going to stretch that as far as I can. This means this. This means also if you're doing nefarious activity, which could, go downstream, I'd like to say I have a role in that, but then you say, okay, well, wait a second. Then what are you doing for all this peer-to-peer stuff? What are you doing about all this porn stuff? They'll say, oh, no, that ain't my problem. So you see where, again, 2 attorneys in one town, a real good living. Yes?
To host systems at Amazon, can I just send those systems that I own in the Amazon cloud, but I really only rent them as a service? Has there been any cases on that?
Not yet.
That's going to be
Oh, yeah. That's what we're, the legal talks that deal with cloud computing and security from that aspect and what we're looking at for that, I'm sorry, you guys are keeping us in business. If you can fix this whole thing, you can put a lot of lawyers out of business, but they're really going nuts with those areas right now.
What areas of recognition is the overlap of what your typical use policy and your wiretapping? And wiretapping seems to trump your typical use policy.
Acceptable use policy and wiretapping. Again, from a private aspect, private employer aspect of life.
Government network. Government network.
Government network. All right, let's 2 things, aspects of it. There is model language, banner language for the government. It was written up by the Cyber Lawyer Working Group, and it was put as part of the Einstein 2, which is an intrusion detection system that's being rolled out to different departments and agencies. This is the fun aspect of life, of where I'm standing. This is publicly available information. I'll admit. I didn't publicly go out and get it, although I did on some of it. This stuff I did publicly go out and get. But as part of that aspect of the model language, it is getting rid of my slide back there of that expectation of privacy. So basically, it's my acceptable use policy, my use policy, and that banner that comes up there is getting rid of that expectation of privacy so I don't have a wiretap violation. It is prohibited to intercept communications. And if you look at the statute, God bless you, because we're talking oral, wire. It's just the words that lawyers use putting these stuff in here to make sure it's inclusive of it is anything, basically you're getting there that's going across a wire or wireless. You can't intercept it. You're prohibited unless you fit under one of the exceptions on why you can. Again, this computer network security is 2511, little a, little I, or little 2, little a, little I. And that's how we do it for computer network security. Again, same thing for a private company. I put it in my acceptable use policy, my banner, and I go through it, and then that's how I'm basically getting it. You've heard about Google, small company, misspelled. They recently, apparently, and this is all New York Times, as a matter of fact. So they recently contacted the NSA for help because they had a problem, apparently. And when they contacted NSA, New York Times reported that they have no statutory authority. Where's this fun, handy-dandy little thing? You guys are probably already there reading anyway. They said NSA has no statutory authority to investigate domestic criminal activity. And said DHS does have authority. That's true, but it's not true. I'm not aware that DHS has authority, or as a matter of fact, I'll say DHS does not have authority to investigate domestic criminal activity. The Secret Service, which is under DHS, and somebody else do have that authority. Customs, Border Patrol, things of that nature. But the gist of it is, when a crime happens to a private company, who are they supposed to go to for help? And in this message here, they said NSA doesn't have the authority for that. So they developed a cooperative research and a development agreement. I have to look because we always call them CRADA, is what it's called. And a CRADA is used in government a whole heck of a lot. We used them in the Army a whole bunch. And it's to do research between a federal government and a private corporation, usually laboratories, to develop some research and some technology. So that's what they're using up at NSA. And that's all I'll say. CERT authority. This is the statute for the U.S. CERT. Not many people know that. Not many people look at it. Not many people have read it. It was written before the CERT was even around. It dealt with an entity that was within GSA, and when DHS was stood up, this authority was transferred to the U.S. CERT. The U.S. CERT has been recognized as this entity by OMB, and they're supposed to provide technical assistance to operators of agency information systems, do vulnerability threat alerts to departments and agencies, and that gets situation awareness. That's what they're supposed to do by statute. That's it. No remediation, no jump out and go help. Now, technical assistance, yeah, if I get asked by a department and agency, they can go out and do that. Now, departments and agencies, however many there are, there's supposed to be 12 to 15, department of this, department of that. Yeah, you get subcomponents, 100 or so, have CIOs. CIOs are supposed to do this for the executive head of the agency because they're in charge. The executive head is supposed to do cybersecurity, and the CIO is supposed to do it for them. If they don't ask for help, they're not going to get it, and that's another aspect. Now, there are things called PDs, presidential directives. The last word in this is very, very telling. When you're talking about authorities, there is one authority and only one authority in this land. Statutes, laws. There's the big constitution above that kind of drive everything down. But the only positive authority to do something in this government is statutes and laws. But from that, you get a lot of executive orders and presidential directives that say, you have this statute, do this way. And so this is the PD that basically says, U.S. CERT, get involved with the private sector to help them out. If they want to come to you, if they want to ask, this is how you can get involved with the private sector. Now, an interesting aspect on this. One of the big problems here is the FAR, Federal Acquisition Regulations. Because if you are a prohibited source, meaning if you're a private company that does business with the government, I can't give you a competitive advantage. So if you're going to bid on contracts, and part of the evaluation is, how's your IT infrastructure? How's your security in that? And you've just come to me and reported a big flaw. I come out there, I help you patch it, do it, and everything. And company B over here has the same flaw, and they don't have that information. I've just given you a competitive advantage. Is this frickin' retarded or what? So, if I make that information publicly available and level the playing field for everybody, so everybody's got the same information so they can fix it, I'm good. How many companies are going to let me do that? Now, there's a way to minimize it, to take the company name out, but then again, think of the people you hang around with after work, sitting at a bar when you've got your laptop up and you're eavesdropping on other people's communications going on there, checking out their wireless routers because you're all using the same Starbucks open network. You're all the same company. So all the companies, so you sit there and minimize the information. It's very hard to get anonymity when everyone's talking about and everybody knows who that happened to. Oh, so back to my positive statute, my positive authority. Hey, there's somebody in the world that has positive authority to investigate computer crime. Whew, it's the FBI. Okay, that's all we need to say about that so I can keep my job. So, now I've got a private company, unclassified network, non-national security system. Is there a duty to report a computer security incident, a computer security intrusion, or a computer security attack? Do I have to report? If he stood up right now and slapped me in the face, do I have to go run down, that's assault and battery, do I have to run down to a cop and say, I got slapped in the face, I'm reporting it? There is no, in this circumstances, there's no affirmative duty to report a crime. I'm not talking about FISMA requirements or government agencies reporting anything to the CERT. I'm talking about a private company, unclassified, non-national security systems. I don't have to report it. I don't have to tell anybody. And if you don't think that happens a lot, I'll go for that. So, what's supposed to happen? Well, here's the aspect of it. You saw the information up there in terms of who had what authority and where. When a private company and something happens to a private company, I can't dictate who they're going to go and ask help for in the government. Yes?
Just one also. They do have to report it.
Okay. Yeah. Different aspect. Okay, from an aspect of where if you've got a breach notification or some aspects where you've lost data breach or something, there are, and you're right, I was staying away from that. So the data breach laws, so there are positive authorities from that aspect. If they deal with classified information, they've got to report it. So there's a whole host of aspects where they could have an affirmative duty. Thanks for bringing that up. There could be a whole host of factors where they have an affirmative duty to report it. I'm talking about a very limited set here for private companies, unclassified information, non-national security, no other, just a breach. Is there an affirmative duty to report the crime? If I can't pigeonhole it into, well, wait, you got data breach here, you've got to report that under several state laws, HIPAA, Sarbanes-Oxley, a whole bunch of things. Right, there could be that affirmative duty to do it. But in this, and I'm just talking about the other aspect that we're dealing with right now, which is the aspect of private company from that, no affirmative duty to report it from that aspect. Well, no. You see, you're going down the criminal path of an aspect of extortion or something like that. I mean, anytime I get a computer security incident or intrusion, the question becomes what that category is going to have to fall over if I need to report it. If it's a breach of my system in terms of the classic where give us $10,000 and we'll bring your site back up. Okay, well if that's private company from that aspect, and I've just been I got a nice little flaw here, and I'm like, okay, great. Do I have to report that? I'm not seeing an aspect. Now here's the fun aspect about obstruction of justice charges. Okay, so this wasn't just Google. There were several other companies that this was related to. So once the information becomes knowledge that they're talking in the government, is there an affirmative duty on the government to tie ends together from that aspect of it? And so there's a whole host of things that come in. So what's Google supposed to do? What's a private company supposed to do if they want to bring information to the government? And as we know, everybody's got friends, partners, colleagues that have gone on and worked at different places. So information is going to come into the government in a variety of fashions. From, again, black letter aspects of law and what's up there, FBI criminal jurisdiction over, investigations of computer crimes. Your CERT has a method for getting it in there, and there could even be an argument made that NSA, because they have an information assurance mission for the .mil, that they have a mission in it. So it's one of those areas that we're all looking at. So, come on. All right, cyber attacks. One of the aspects, because every time we hear something, we see it's an attack. We've been attacked. This is an attack. As far as I know, and I'm in that camp where the United States has never suffered a cyber attack. Now, my genesis or my foundation for saying this, because the President of the United States is the only person who makes a determination on whether we've been attacked. Based on the totality of the circumstances that he is faced with, his objective and subjective belief, he steps up and says, this is an attack. Pearl Harbor, 9/11, the bombing of the embassies, things of that nature. These are all made by one and one person only, the President of the United States. And so far, I haven't heard him. Actually, this is the problem I've got. I could lose my job. Sorry, Mr. Obama, President. They always say, we're under attack. This is a cyber attack. I do hear them saying that. I don't think they're correctly using it, because that would invoke a whole bunch of things that no one's saying. Multiple agencies do cybersecurity. We've talked about that. This is what I get for using my kid's clicker. All right, that's what I want to go back to. Sean. All right. Apologize, this is at the bottom. Sean Condren wrote a very good law review article about dealing with this. Homeland Security is the Department of Homeland Security's job. Hey, it's in the title. Defense is the Department of Defense. If it's an attack, the Department of Defense has jurisdiction. If it's security, Department of Homeland Security would have jurisdiction. So from that. Now, this goes back where words are very important. When you go back out there, please use your words carefully, because you're going to be dealing with attorneys or policymakers. And by the way I say this, this Moore's Law, Metcalfe's Law, I'm trying to push Clark's Law out there. It's not very well known, but it's for the legal profession. You're dealing with lawyers. You need to explain it to us in a third grade level so we can understand the technology. We're not geeks. We know it's chic to be geek. We wish we were. The reason we became lawyers is because we couldn't become geek. The only thing we know how to do with math is take a third of whatever it is and go home. All right? And we know how to have the 3 martini lunch. Notice how we work in threes, thirds, threes. So you need to explain it at a 3rd grade level, because I need to turn around and explain it to a judge at a 1st grade level. So get involved early and often with your attorneys. Also, pick your words carefully. If it's a security event, say that's an event. Years ago, the very first guy I had who gave me a migraine after 5 minutes of being on my first job in technology, he said, "What's the law of the internet?" I said, ECPA, this, that. And I think he goes, "No, RFC." And of course, I'm brand new, and I'm like, I have no idea what the hell RFC means at all. But law of the internet, definitions. If it's an event, call it an event, incident, intrusion, call it that, attack, call it that. Use your words carefully. If you've got someone really hammering your network and it's only your network, call it an intrusion. Now, there are definitions in DoD of what attacks, defense, exploitation, and operations are. There's definitions of what a hostile intent is, what a hostile act is, in terms of whether we can now put forward the standing rules of engagement. And by the way, the standing rules of engagement give us our sliding scale of how we can respond, and they are there for the cyber world also. In the other direction of the cyber Pearl Harbor, Paul Ohm, who's a fellow colleague from DOJ, wrote a great article about the myth of the super user. All right? And it basically says, you know, cats and dogs living together, mass hysteria, the whole aspect of it. Well, he kind of went back and said, look at who's going to actually take down the network and who would want to. And it even gets into the whole aspects of getting down to the people that you think would want to do it if you can't control it. And even if terrorists wanted to take it down, do you think the people who are funding them would be really pissed off if their funding and their problems were going down the drain because they lost the internet of it? So, yes, we need to do several things to secure our networks better than what we're doing now. We need to have the technology, the innovation to move forward on this. But the hyperbola that we're getting of this threat and the concept that it's going to happen, that we're going to have a cyber Pearl Harbor, I kind of pull back on that a little bit. Let's see. Again, one of the arguments I always hear is, well, there's such little research done on cyber warfare, cyber attacks. The legal community really hasn't looked at it that much. We really need to develop this. We really need a law. We really need, deterrence strategies. Something. The work has been done. It's out there, and it's easy to find if you're in the field ad nauseum from our aspect. This is what I should get. So as we can see, it's there. The last thing I'm going to point out is there's a move to reform the Electronic Communication Privacy Act. The Digital Due Process, digitaldueprocess.org is moving. It's got everybody signed up for it. I think Microsoft, Google, Yahoo, everybody signed up for it. You've got a lot of leading scholars on this from Oren Kerr of George Washington University, EFF, and a whole bunch of folks are looking to try to bring the Electronic Communications Act up to speed with the communications and the technology that are going on. So if you're curious about that, you can dive in with those folks and take a look at that. Oh, and that was it. So my contact information just went right by. Maybe that's a good thing on it. So see if I can get contact information up. Any questions?